May it please the court, good morning. Brett Fisher of the Boatman Law Firm on behalf of the appellant, Mr. Loboda. I'd like to reserve 5 minutes at the end for rebuttal, please.
Okay.
This is a foreclosure case, this is a foreclosure case in which Mr. Loboda is appealing the trial court's denial of his motion for involuntary dismissal that was made at the end of the bench trial. The trial court, in denying Mr. Loboda's motion, ruled that that Ocwen had established a prima facie case that the initial plaintiff, GMAC Mortgage LLC, had standing as the holder of the note under a blank endorsement, undated blank endorsement, at or before the time this lawsuit was filed. We contend that the trial court erred in that determination because no evidence was presented that established when the initial plaintiff, GMAC Mortgage LLC, obtained possession of the original note, and that no evidence was presented as to when the blank endorsement was effectuated on that note.
What's the operative complaint?
That's actually an interesting question. The initial,
what is the complaint that the parties proceeded to trial on?
Well, the amended complaint in paragraph 1 only stated that Ocwen is the holder as of the date of execution of this complaint. And the date of execution
Is that not the operative complaint?
I would say no, simply because...
Did the trial court not previously grant a motion to dismiss and permit a new filing?
It did permit a new filing. The problem was that the amended complaint did not attempt to relate back to the date of the original complaint. And when that fact is considered in light of Rule 1.260C, which is the rule that Ocwen substituted under, the substituted plaintiff only acquires the standing of the original plaintiff. And I'll answer that question in a little bit more detail, Your Honor, at the end, if I could get back to my argument. Did I sufficiently answer your question, actually? So it's kind of unique in that the amended complaint can't really relate back because it didn't really attempt to. So the operative complaint would be the initial one and the fact that Ocwen had to show that the initial plaintiff, GMAC Mortgage LLC, had standing under the blank endorsement as of the date this lawsuit was filed. So to that end, in order to establish a prima facie case, Ocwen was required to show through competent and substantial evidence both of those elements. One, that they were in possession, and two, that GMAC Mortgage LLC, that the blank endorsement was present on the note when GMAC Mortgage LLC was in possession of it. So as appellee contends, it's their position that simply stating through the witness at trial that GMAC Mortgage LLC was the holder at the time this was filed is sufficient. And we would contend respectfully that that's incorrect, and that it's shown to be incorrect when you look at the cases such as Stone or May that were cited in our brief, where the courts are trending to require not only that you simply allege the elements, i.e. that you're a holder, that you're in possession, and that the endorsement occurred, but that you provide substantive evidence which supports those allegations. For example, in Stone, the witness worked for the previous lender. She was aware of the purchase and sale agreement through which the subsequent lender acquired the note. That purchase and sale agreement was entered into evidence, and she was able to testify as to each and every one of those events and had personal knowledge of those events. So here, when moving to the evidence that was produced at trial, we would contend that when you look at the documentary and testimonial evidence, either individually or as a whole, it doesn't establish either of the elements. The documentary evidence was simply 3 exhibits. Exhibit A was the notice of filing, which was filed after the lawsuit was filed, 22 days after, with a copy of the original note. Now, what's important about that, by way of brief background, is that the original note that was filed 22 days after the complaint was filed was different than the copy of the note that was attached to the complaint. The copy of the note that was attached to the complaint had a single endorsement to GMAC Bank, whereas the original note had 2 new endorsements, one from GMAC Bank to GMAC Mortgage Corporation, and a second undated blank endorsement from GMAC Mortgage Corporation. So at that point, the filing of the original note at trial, notwithstanding the fact that the witness authenticated it, does not establish standing because the endorsements are undated, and again, it was filed after the lawsuit was filed, and that rule finds support in the May case. Secondly, the Exhibit B, which was the assignment of mortgage, was filed in April of 2013, so that can provide no support as to the standing. And finally, the payment history that was entered into evidence is Exhibit C. While it did contain entries that predated the filing of this lawsuit, as Mr. Clonch, Ocwen's only witness at trial, testified to, the payment history was maintained simply to keep records of payments and disbursements. It didn't, there was no, the payment history was not maintained to keep evidence of transfer of the note or endorsements or things of that nature. So the documentary evidence as a whole provides us with no direct support as to the two elements that were required and or support from which an inference can be based to establish either of the two elements. Now, when looking at the testimonial evidence that Mr. Clonch provided, we would contend that even when you consider the answers and the testimony that was elicited and essentially rearrange it chronologically, it still does not establish either of the two elements. In reviewing that evidence in the light most favorable to Ocwen, it can really only be ascertained that Mr. Clonch worked for GMAC prior to Ocwen acquiring the loan, that GMAC used the program Looking Glass to house copies of the note in addition to other pertinent loan documents, and that when Ocwen acquired GMAC, it also acquired Looking Glass and continues to use that system for the same purposes. And Mr. Clonch testified that from that review, he was able to authenticate the note, he identified the 3 endorsements on the note, and he also stated that he was able to determine that GMAC Mortgage LLC was a holder of the note at the time this lawsuit was filed. So that evidence, that testimony alone does not provide us any direct support as to when GMAC Mortgage LLC obtained possession of the original note, nor does it provide us any evidence from which it can be inferred as to when GMAC Mortgage LLC came into physical possession of the original note. And as a second matter, the evidence does not provide any direct support as to when the blank endorsement was effectuated, nor does it provide any support for, to give us an inference as to when the blank endorsement was effectuated. And that's why we cited the Sosa case in our reply to show that the courts are requiring not only a witness testifying as to the fact that they're the holder, but then establishment of both of the elements. In Sosa, they claimed standing under I believe it was a specific endorsement, but there the witness never testified as to the date the endorsement was effectuated. He did testify as to the date that the servicer obtained possession of that note. However, that alone was insufficient. Both elements are required. So we respectfully contend that the appellee's reliance on McLean for the proposition that all that is required is for the witness to testify to the fact that they hold the note is improper. That case specifically held that where Chase filed an affidavit stating that they were the owner and holder of the note, that was insufficient. It was insufficient because it didn't provide any other substantive information as to how it acquired the note, whether it came into possession of the note, when it came into possession of the note. So the court specifically held there that absent that information, an affidavit that simply states that the plaintiff is the owner and holder of the loan without more is insufficient. And I've been unable to find, and appellee's brief doesn't point to any cases in this state that hold for the proposition that all that is required is merely conclusory evidence at trial that the plaintiff is the holder. And as from a final standpoint, the appellant is aware of the issues raised in the Falk opinion from this court as to the issues with the current rule of standing, whether or not standing should be changed as to allow plaintiffs to simply prove standing as of the time final judgment is entered, as opposed to prior to the date the lawsuit is filed. And without going outside of the record, I would represent that the issues raised in the concurring opinion in that case with respect to a party benefiting from the pendency of the foreclosure action are not present here. And more importantly, from a policy standpoint, as the Supreme Court has recognized, the purchase of a home is still one of the largest transactions that Floridians make, such that from my experience, the standing defense is the one, if not the most effective defense in resolving foreclosure actions in a timely and efficient manner, such that it allows a waiver of deficiency, so that the homeowner is alleviated from the burden of having to pay the debt from any final judgment over the course of time, which again allows the homeowner to get back on their feet financially, start restoring their credit and things of that nature. So we would respectfully ask for this court's consideration of those facts when it's rendering its opinion, and If the justices have no other questions.
Thank you.
Thank you.
May it please the court. My name is Masimba Mutamba, and I represent the appellee in this case, Ocwen Loan Servicing. This case comes to appeal because the defendant in the underlying action sought a reversal of the trial court's opinion with respect to a denial of the motion to involuntarily dismiss plaintiff's case after the completion of trial. Not at summary judgment, not prior to any discovery, but at trial, after the trial court had already assessed all the evidence available to it after trial. This point is important because the appellants forget that in the case law they cite, what's been repeatedly observed in many of the districts of the state, particularly in this, is that when there's evidence sufficient to indicate the fact that through some means the plaintiff has been able to establish standing at inception of the suit, however that evidence is garnered by the time of trial, the court is well within its rights to find on a preponderance of the evidence standard that the plaintiff has shown sufficient standing. Your Honors, first, as rightly pointed out by the appellant, the issue at this case is whether the substituted plaintiff, Ocwen Loan Servicing, had the right to foreclose by virtue of the standing of its transferor. GMAC Mortgage LLC was the initial plaintiff in this case, and so it's instructive about whether or not GMAC Mortgage LLC established sufficient evidence at trial that they had standing to bring the suit. The answer from the testimony of Mr. Clonch, who was available at trial, and from the evidence produced not at the inception of the lawsuit, but by the end of the suit and by the end of all the evidence accumulated at trial, it was firmly established that GMAC did in fact have holder status at the time of the filing of the complaint. Now, holder status, to break this down through the language of the McLean versus JP Morgan case, holder status would encapsulate everything with respect to possession and the right to enforce the mortgage at the filing of the complaint. In the McLean case, the instructive point is that there isn't any one piece of evidence that the plaintiff is bound to in order to establish that they have standing. The appellants would like to point out to the fact that the original complaint had a copy of the note that did not have all the endorsements. However, what's instructive is this was not at summary judgment. This was after an amended complaint. Take all those pleadings along with the testimony presented by time of trial at the close of plaintiff's evidence, and by the time of trial, there was the full original note, which the witness, the testifying witness, Mr. Clonch, rightly indicated that he had reviewed and he had vetted as the original note in this case, with 3 endorsements, all of which supported the chain of title that allowed Ocwen Loan Servicing to continue as plaintiff in this case. In addition to that, the testimony of Mr. Clonch can't be mistaken. Mr. Clonch's testimony was that the GMAC was holder of the note at the time of the filing of the complaint. This testimony covers both issues relating to possession, as well as the fact that at the time of the complaint, GMAC was in possession of the full original note that had all the valid endorsements that would qualify it to be a holder and to seek foreclosure on this case. In the McLean case, they point out that an affidavit attesting to the holder status prior to the filing of the foreclosure would be enough. Therefore, Your Honors, the fact that you have a testifying witness at trial should be adequate evidence of the fact that the plaintiff asserts their right to file the foreclosure and therefore fulfills the standing requirement. In the Riggs versus Aurora Loan Servicing case, the same similar situation as with this case occurs, namely a substitutive plaintiff took control and sought for filing of the foreclosure. In that case, as in this one, the instructive thing was whether that plaintiff could sufficiently prove that their predecessor plaintiff in interest had established standing at inception on the lawsuit. This was clearly done in the Riggs case as it was clearly done here. When you add both the fact that by time of trial, there's a full complaint, there's a full note with all endorsements, and there's a testifying witness that asserts unequivocally, and the record shows this at Doc 12-8 in the trial transcript, that, quote, GMAC Mortgage LLC was the holder at the time this, meaning this complaint, was filed. That is how the trial court interpreted the testimony of the witness, and that is the basis by which the trial court indicated that there was a preponderance of the evidence, that there was sufficient proof of standing. Your Honors, this court should also affirm the foreclosure judgment reached by the trial court, because the trial court properly denied the motion for involuntary dismissal. On an involuntary dismissal motion, the key issue is whether or not the non-moving party has established a prima facie case. In this case, this would be a prima facie case for foreclosure. Under the Ernest versus Carter case out of this court in 1979, four criteria are established for what a prima facie case for foreclosure is. First, that the plaintiff shows evidence of an agreement. Second, that the plaintiff shows evidence of the defaulted issue in the foreclosure. Third, that the plaintiff shows acceleration of the loan to maturity. And fourth, that the plaintiff shows the amount due. All four of those things were clearly established on a prima facie basis in this case. Ocwen did show evidence of the agreement through use of the mortgage that was admitted into evidence in this case. Ocwen showed evidence of the default both through documentary evidence and through the testimony of the witness. Third, Ocwen also showed the acceleration of the loan to maturity through the filing of the complaint, the original complaint, first by GMAC Mortgage and then by Ocwen itself in the amended complaint. And fourth, in its final closing in the trial, Ocwen showed the amounts that would be due to it in a judgment. All of these were established. That is the full scope of the prima facie case that the trial court looked at to determine whether or not to grant the motion for involuntary dismissal. Your Honors, it's...
I don't think it's been pointed out yet, but if I'm not mistaken, the Ocwen witness had previously been employed by GMAC.
That's correct, Your Honor.
So he was familiar with GMAC's records, GMAC's computer system, GMAC's documentation, et cetera.
Correct, Your Honor.
Oftentimes we see these cases, the witness comes in and he's with 3 steps removed from the original lender, but that adds additional credibility, I would think, to his testimony in this case.
Yes, Your Honor, and that has a direct bearing on whether or not this particular witness could speak through the business records exception and could speak to the trustworthiness of the evidence that was shown with respect to whether or not the plaintiff had standing. Oftentimes under WAMCO, Your Honor is right. There would be more loopholes that the plaintiff would have to try and go through to establish the fact that an employee for the new service could speak to the old servicer's records. But we don't even have that in this case. And so accordingly, the testimony given by Mr. Clonch in this case is even more persuasive when he speaks to the fact that, again, unequivocally, as the record shows, GMAC Mortgage LLC was a holder and did have in its possession the note at the time of the filing of the complaint. Your Honor, coming back to the issue again of the denial of the involuntary dismissal, under Day versus Amini, which is out of this court in 1989, it would have been improper for the trial court to look outside the scope of the prima facie 4 elements that I addressed earlier to determine whether or not an involuntary dismissal was warranted. The trial court was not permitted to improperly weigh the evidence or to make decisions regarding the credibility of the witnesses when weighing Ocwen's prima facie case for foreclosure. Therefore, Your Honors, and the record clearly reflects this in the trial court's decision to deny the motion, the trial court was concerned that on the preponderance of the evidence, all that had been established was a prima facie case where the plaintiff, again, through testimony, as is allowed in McLean, in addition to the original note that had the endorsements ending in an endorsement in blank, that all of those combined pieces of evidence clearly established to the court's own, to the trial court's own satisfaction that the motion should be denied since there was a prima facie case for evidence. Your Honors, I yield the rest of my time if there's no other questions, but for these reasons, the appellee respectfully requests that this court reaffirm the decision below. Thank you.
Thank you.
With respect to establishing its status as the holder, appellee hasn't actually pointed to any evidence other than the statement by Mr. Clonch that they were the holder. They haven't pointed to any evidence from which it can be inferred that they were in possession and or that the endorsement occurred prior to the date this lawsuit was filed. And with respect to appellee's argument that as long as the lender proves standing as of the time the final judgment is entered and or as of the time of trial, that goes against all of the precedent from this district court and every district court of the state that standing must be proven as of the time the complaint was filed. And with respect to Mr. Clonch working for GMAC, prior to working for Ocwen, he didn't indicate when he worked for GMAC. We can see how it could support an inference that he worked for GMAC prior to the time the complaint was filed. However, we would submit that that does not establish the fact that GMAC Mortgage was in possession of the original note and or that the blank endorsement was effectuated prior to the date the lawsuit was filed. Again, he testified that he reviewed a looking glass program and that from that program he was able to ascertain that they were the holder. However, he didn't identify any of the documents that were in this program and or any of the other information. And it's long been the rule that any records or other documents identified but not entered into evidence at trial do not constitute evidence upon, or do not constitute competent substantial evidence upon which a judgment can be based and or that can be considered in reviewing whether or not the elements have been established for a prima facie case. And more importantly, the court wasn't weighing or weighing the evidence or looking at the credibility of the witnesses when it was determining whether or not the elements were met. It was simply looking at what had been proffered and determining if it supported that they were in fact in possession of the note and that the endorsement had occurred prior to the lawsuit. And here that hasn't occurred. Again, in the Sosa case, you have a situation where the witness is saying, yes, we're in fact the proper party was standing, and he identified the endorsements on the note, just like Mr. Clonch did, and he also testified that they were in possession of the original note, which Mr. Clonch did not do here. And notwithstanding that fact, the court still found that there was not a prima facie case established because he didn't testify as to when that endorsement on the note occurred. Another case that holds to this same proposition is the Kiefert case, 153 Southern 3rd 351. While not cited in my brief, it holds for the exact same proposition where witness testifies that they're the holder, testified that they were in physical possession or to one of the other elements that are required, but doesn't complete the circle, doesn't testify to both elements, then standing is not established. And going back to your question, Your Honor, just feel it necessary to address it. What was kind of interesting about this case is that Ocwen was substituted in May of 2013 as the plaintiff, whereas the amended complaint was not, or leave to amend was not granted until October of 2013. Now, the motions were filed, I believe, simultaneously and or right around the same time, that being the motion to amend and the motion to substitute. However, Ocwen was substituted and was operating under the operative initial complaint before the amended complaint was entered. And more importantly, the order that grants leave to amend simply states that the amended complaint shall be deemed filed. And looking at those facts together with the allegations of the amended complaint, they do not relate back and or obviate Ocwen's obligation to have to prove that the initial plaintiff, GMAC Mortgage LLC, had standing as of the date this lawsuit was filed. So we would respectfully ask this court that they reverse the trial court's denial of the motion for involuntary dismissal and enter an order remanding this case back to the trial court for an entry of dismissal in Mr. Laboda's favor.
Okay, thank you.
Thank you.
Thank you both. Well, I think we're going to have to take a break. Well,
11 is not here yet, Joe? 11 o'clock. They are here.
they are?
Keep going.
Yeah, great. Then we'll call our next case.